Hi everyone, welcome back to my channel. Today's video we're going to be talking all about the differences between two types of judicial clerkships. So on the one hand, we have Federal District Court clerkships, and on the other hand, we have Federal Circuit Court clerkships. So what are the differences? Should you do both? Should you consider both? If you're a law school applicant or a law school student, then this video is perfect for you. For those of you who don't know, my name is Sephora. I'm a licensed attorney and law school coach. You can always go to talkingthecurve.com for law school coaching. Okay. So let's jump into the video. I am first going to talk about Federal District Court clerkships. So the Federal District Court clerkship, if you think about it in the hierarchy or the court system, you have the Federal District Court clerkships first, so that is the trial court. Then you have Federal Circuit Court clerkships, and that is the appellate court. And then you have in the Supreme Court. So these clerkships are things that you do after you have graduated from law school. So there's a little bit of confusion there where some people are like, I'm clerking, and they haven't even gone to law school. No, you're not. Not in the sense of how attorneys refer to federal court clerkships. So that's the first thing. So at the district court level, that is where you are clerking for a federal district court judge. So this judge has gone through the nomination process, right? So a president has chosen them to or nominated them for a certain district court in a certain state, and then they have been gone through Congress, gone through all of that and approved, and now they are a sitting judge. And you are clerking for that judge, right? So at the district court level, this is where you get to engage in everything trial stage. So for instance, if you think about me suing you, then that is where this all begins, right? So that initial lawsuit will go to you, and then not you, the clerk, but you, me suing you. And then you have a couple of options, right? You can file a reply, or you can file a motion to dismiss, or you could even file a motion for summary judgment, whatever it may be, right? So if you file one of those motions, then that goes through the district court system. And then you, as the federal law clerk, you are the one who gets to see all of that, right? So you're getting to see that back end. So as a federal district court clerk, that is what you are working on, is that back end side of that front end of the litigation. So when you see a motion to dismiss, if it's assigned to you, depending on how your judge assigns those things, then you're going to be working on that motion to dismiss. So you're going to be researching, and you're going to be writing draft opinions or memorandums to your judge to recommend whether this case should be dismissed or whether specific claims only within the filed lawsuit, so the complaint should be dismissed. They file a motion for summary judgment, maybe the same thing. Of course, this means you're also looking at the legal standards, right? So you're going through all of the necessary research. So that's one of the things that you are doing at this district court level, is you're engaging in the litigation at its initial stages, right? So at the trial stage. Other things that you get to do, which I really enjoyed when I was doing my federal district court clerkship, was you get to handle emergency motions. So emergency motions may be like temporary restraining orders or TROs, right? Or injunctions. And as those come in, again, depending on how your judge does it, those may get assigned to you, and you may have a quicker turnaround time to do some research and give suggestions or write memos to your judge to recommend on how that may happen. Those as well may go to a trial. So different judges, or a hearing, I should say, different judges do this differently. Some judges, but not all, may like hearings, and so they do them a lot. Other judges may not. They just may issue a ruling without doing a hearing. That is judge dependent, as is a lot of things in these federal district court clerkships and circuit court clerkships as well, right? So that's another thing you're getting to work on. Also at the federal district court level, you get to go to trials. And this was probably one of my favorite things, right? You get to see trials that run the gamut of legal issues. So tax issues, corporation trials, criminal trials, civil trials, just tons of different issues while you're doing your clerkship. And you get to, especially with the trial you worked on, it's going to be interesting to see, like, okay, like, what happens here? Like, is it the government versus the defendant? Is it corporation against corporation? Is it whatever it is, right? Plaintiff and defendant, either way, you get to see a bunch of different kind of different ways of seeing the litigation system actually in action, right? Seeing the court system in action, seeing trial in action. You get to see voir dire. So that's when they're actually going through the process of picking the jury. You get to hear when the attorney says they want to strike a juror and their reasons for why. I mean, just the entire process at this district court level gives you a really high level of understanding of how the litigation process works, especially on the back end, right? The other things that you get to do at this district court level is possibly listen in on or attend discovery calls or discovery hearings or whatever it may be, right? So if two parties have a discovery dispute and they want to involve the judge, and the judge does have that phone call or does have that hearing or whatever it may be, then you get to be a part of that. So I specifically remember one of the cases I was working on, my judge held a hearing, and so I got to hear the two arguments from the opposing sides on which way the discovery dispute should go. Of course, your judge is also setting trial schedules, setting discovery schedules, all that stuff you get to be involved in if your judge allows you to at that trial stage. This district court clerkship, you're getting a really strong understanding of what it's like to kind of be a trial attorney. And if my camera dies, I did buy any batteries, so I will still grab that. But you're really getting this understanding of what it's like to be a trial attorney from the back end, right? So a heavy emphasis on from the back end, because when you're in law school, you don't really get to see okay, but what happens after a motion to dismiss? What happens when someone files a complaint? What happens when this? Right? And you get to learn more about just the deadlines, the timing for response, all those different types of things. A lot of your job is that research and writing, like I was talking about, because you do have to handle those motions and write those opinions or recommendations or memos to your judge, attending trials, right? And so it may involve some research on rules of evidence, because that goes on in the trial. Also at the district court level, and also as we're talking about trials, you get to learn more about different argumentative styles, right? So you get to see two attorneys and what their styles are like, and maybe even envision what your style would be like if you were a trial attorney, and different things along those lines. You get to go and talk with the jury if your judge allows it. So my judge did allow us to go and talk with the jury. So we asked them, was this helpful? Why did you come out this way? Why did you find the defendant not guilty? Or why did you find him guilty? What from this attorney's presentation was helpful? All those different types of things. So at this district court clerkship level, you're really getting a substantive understanding from the back end of that litigation phase and the trial at the district court phase. At the trial level, I should say, and improving your research and writing skills as you are assisting the judge with everything that I just talked about. So now on to the circuit court level. So the circuit court, the next level up, this is the appellates, right? So if you lose at trial or there's an intermediate appeal, that is what comes up to the circuit court level. Circuit court clerkships, there are no trials like there are in the district court level. Instead, there are oral arguments. And so oral arguments is really just the parties and not the witnesses. And the panel of judges get to ask you questions while you are giving your argument. So at the circuit court level, what happens is the parties are submitting briefs. And you have the appellate brief, which is the person who is appealing the ruling below. And then you have the appellee brief, which is the person who has not appealed, or the person who is rebutting the appeal, for lack of better words. And those briefs are coming to you as the clerk to review, and in this case, a little bit similar to the district court, to review and decide, okay, was the trial court right? Whether it was the judge, whether it was the jury. And of course, all of that involves more complicated and distinct levels of review or standards of review that you would determine through doing subsequent research after reading all the briefs. At the circuit court level, there are also amicus briefs. And so that is where people who are not necessarily a party to the litigation can file a brief in support of one side, and then you read those as well when you are going through and reading all the briefs before starting your research, right? So when you're starting your research of things, the same thing, you're coming to a determination on whether the lower court was correct and whether we should affirm, reverse, remand, dismiss, right? Whatever it may be. And then for some of these cases, like I said, you go to oral argument. And so at oral argument, that's when the parties are, at least in the case of some circuits, arguing before a three-judge panel. right? And so the 3-judge panel will receive your bench memorandum if that is the way that your circuit does it. But definitely you'll be writing a memorandum at the very least to your judge to recommend how this appeal should come out. And then those judges are then having conference and discussing what they think should happen with the appeal, how it should come out. Some circuits, but not all, do en banc. So that's ENBANC. And that is where after a panel has issued opinion, so after they heard the argument and then written an opinion and then published the opinion, a party can petition or, in a sense, appeal the panel's opinion and request rehearing en banc. So rehearing en banc is when it goes to a panel of all of the active judges on a particular circuit, and then the active judges get to vote on whether they rehear the case en banc. If a majority of the judges decide to hear it en banc, then it will go en banc, and the same process will happen again. But instead of a panel of 3 judges or however your circuit does it, whether it be 5 or whatever, it's all of the active judges on that circuit, and then again, conference, and then making that decision. Different circuits do things slightly different. So for example, I know some circuits do not have en banc. Instead, it's more of like an email exchange between the judges when they're kind of deciding like, okay, is this opinion going to be changed or what should happen? And then they're doing more of like an informal voting system instead of actually having a whole separate type of hearing. Usually with the en banc, it happens in one state within the circuit. So for example, if you're in the Second Circuit, maybe the en banc is happening, if the Second Circuit has en banc, is in New York, for example. Or if you're in the Fifth Circuit, the en banc is in New Orleans. Or if you're in the Ninth Circuit, the en banc is in California, right? But that's just an example. Not all those circuits actually have en banc. But so all of the judges are then convening or meeting in that one state to rehear that panel or rehear that case amongst all of the active judges. So here as a clerk, like I said, you're reading those briefs, you're writing that bench memorandum. In other cases, maybe as well, you're also replying to other clerks. So clerks from other circuit judges, bench memorandums, and providing that to your judge to let him know your view on that case. And the appellate, the circuit court level, you have a lot longer of a time to work on cases than you did at the district court level. So I found the district court to be a lot more fast-paced because you had to knock those motions out because there was a lot coming in, and you have something called the CJRA list that you have to have completed. Whereas at the circuit court level, you have a little bit more breadth in terms of getting your work done, but I do find that it was more intellectual, right? So the issues were often more convoluted, more complicated, requiring a lot more research and a lot more in-depth level of writing. And so you got to spend more time kind of with your thoughts and more time developing your arguments, which I really enjoyed. Also, the differences between the district court and the circuit court. I think the circuit court is a little bit more isolated, whereas at the district court, there was a lot more, I want to say like collaboration. The circuit court is, in my opinion, a little bit more isolated because really, like, especially if you have a bench memo due, especially if for argument coming up, you're really in-depth involved and working on your case and making sure you get it right. So those are like some of the main differences, not all, but some of the main differences between a federal district court clerkship and a federal circuit court clerkship. I 100% think that everyone who is interested in going into litigation should do circuit court clerkships, district court clerkships. I personally chose to do both, because I didn't know whether I was really interested in trial work, whether I was interested in appellate work. And so doing both really gave me that insight into both of the different things. And because I was at a top law school, I did have that ability, top law school where I finished top of my class, I did have that ability to put in the work necessary and be able to successfully land both the district court and circuit court clerkship. I mean, that's also another reason why I always say knowing your goals on the front end will allow you to make the investments you need to make at the application stage so that these things can be a reality for you at the back end or once you graduate. So I do have a video already on why I think everyone should do a federal court clerkship and all the benefits of it. So if you haven't watched that, go ahead and click that video next. And if you're interested in getting law school coaching, go to toppingthecurve.com. Thank you so much for watching this video. Don't forget to follow me on social media at toppingthecurve on everything. And I will see you guys on my next video. Thank you so much for watching. Bye.